The European Union just passed a landmark law that's set to change the future of artificial intelligence. Today, we're diving into one of its most powerful sections, Article 92. You can think of it as a master key, designed to give regulators access to the most advanced AI systems on the planet. This analysis is based on a commentary developed under the scientific oversight of Professor Vihar Kiskinov.
This really is the central question of our time, isn't it? As AI gets more powerful and integrated into every part of our society, how do we make sure these incredibly complex systems are safe, fair, and transparent? Well, the EU's answer is a formidable new oversight mechanism designed to do just that.
Okay, let's unpack this idea of a black box. The most advanced AI models are so complex that often even their own creators don't fully understand why they make certain decisions. Article 92 of the AI Act is designed to be that master key, giving regulators the legal authority to unlock that box and investigate what's actually happening inside.
So, what does this master key actually do? Let's get into the specifics of Article 92. This is where the EU gives its new AI office the legal muscle it needs to investigate the big, powerful AI models, the ones that could have a massive impact on our society, our economy, and our fundamental rights. Now, the law specifically targets what are called general-purpose AI models. These aren't your simple, single-task AIs. No, these are the foundational systems, the powerful engines that drive everything from sophisticated chatbots to image generators. And because their capabilities are so broad and can be applied in countless ways, they require this special level of scrutiny.
And this is where it gets really interesting. The AI office can demand to see everything, not just the paperwork, but they can get their hands on the model itself through its API. And in some cases, they can demand the holy grail, the source code. That's a level of access that is virtually unheard of for regulators in the tech world.
Of course, this power isn't unlimited. The AI office can't simply decide to audit any model at will. There are two very specific conditions, or triggers, that can launch a formal investigation. Let's examine what they are.
The first trigger is simple. A company isn't being transparent enough. If a provider fails to supply the necessary information for the AI office to verify compliance, that alone can start the process. The second is more alarming. A panel of scientists can raise a red flag, a qualified alert, if they believe a model poses a systemic risk. Think of an AI used for medical diagnoses that starts giving dangerously wrong advice, or a logistics algorithm that disrupts supply chains. That's the kind of risk we're talking about.
So, once an audit is triggered, what happens next? The process is very methodical. It begins collaboratively, but is equipped with significant enforcement powers if a provider fails to cooperate. Let's walk through the four main steps. First, there's a structured dialogue. This is the cooperative attempt to resolve concerns and gather information informally. If that doesn't work, things get serious. It escalates to a formal, legally binding request for access. Next, independent experts are called in to conduct a deep dive evaluation, a full technical and legal audit. And finally, the Commission makes its decision based on those findings, which could range from no problem here to major fines and orders to alter the model.
So the crucial point here is this distinction. The structured dialogue is a chance for providers to clear things up collaboratively and proactively. The formal request, however, is compulsory and enforceable. Ignoring it doesn't just look bad, it can lead directly to penalties. This two-tiered approach encourages cooperation while ensuring regulators have the authority they need. This brings us to the central challenge of any technology regulation. How do you ensure safety and protect the public without stifling the very innovation that drives progress? Article 92 sits right at the heart of this fundamental tension. On the one hand, the goal is to build public trust, to protect our fundamental rights, ensure safety, and make sure the market is fair for everyone. But on the other hand, there are real costs. This kind of regulation can be expensive for companies, both large and small. It could slow down the incredible pace of innovation we're seeing, and if a popular service has to change its AI model, that could disrupt the experience for all of us who use it. And this really gets to the heart of the matter. As the source commentary points out, this can't just be about regulators versus tech companies. For this to succeed, it has to be a collaborative effort, with everyone, regulators, developers, and outside experts working together toward the common goal of trustworthy AI.
Now, let's zoom out, because this isn't just about Europe. The AI Act is likely to have a global ripple effect, thanks to a phenomenon known as the Brussels effect. If we compare the EU's approach to what we see emerging in places like California, a key philosophical difference appears. The EU is focused on ex ante, or proactive, evaluation. It aims to identify and mitigate risks before a system is widely deployed. The U.S. model, so far, has been more ex post, or reactive, relying on transparency and lawsuits to create accountability after a system is already in the market. The theory behind the Brussels effect is simple. Global AI companies may find it easier to adopt the EU's strict standards everywhere, rather than build different models for different markets. If that happens, the EU AI Act could become the de facto gold standard for AI regulation worldwide. So we end with the core dilemma. Article 92 is an ambitious and powerful tool, a serious attempt to hold AI accountable. But the ultimate question remains, can this framework strike the right balance? Can it protect us from AI's most significant risks while still allowing us to harness its incredible, world-changing potential? That is the challenge that lies ahead for regulators, developers, and all of us.